Hi, I'm Diana Isaac. Today, I will be discussing the topic of division of property and assets in the context of a married couple that undergoes a marital breakdown. In Ontario, married couples divide their property under a regime or formula called equalization. The first step in equalization is to determine each party's net family property. In order to do so, each spouse calculates the total of their assets as at the date of separation and subtracts from it his or her total debts. The value of the total assets that the spouse brings into the marriage is also deducted from the date of separation figure. The result is known as net family property. Next, one party's net family property is subtracted from the others in order to determine the difference between their net family properties. The spouse with the higher net family property figure pays the spouse with the lower net family property 1/2 of the difference. If either or both of the spouses end up with the negative net family property amount, the figure becomes a zero because parties cannot owe a negative amount of equalization. It is important to bear in mind that there are certain exclusions and deductions that are claimed within equalization. For example, an inheritance or a gift provided by a third party to the spouse during the course of the marriage is considered an exclusion to the equalization formula. The spouse claiming an exclusion or deduction in equalization carries the burden of proving this in order to be entitled to it. The matrimonial home is also given special treatment in equalization, specifically if it is brought into the marriage or inherited or gifted by a third party. It is not a permitted exclusion or deduction. Lastly, equalization must be claimed within 6 years after the date of separation, or within 2 years after divorce, or within 6 months from the first spouse's death, whichever occurs first, or else the spouse can be barred from ever claiming equalization in the future. Thank you for listening.